Okay. Just wait for people to return. Yeah. Well, it doesn't look like we have Mr. Campbell yet. Mr. Kelly, are you content to proceed acting on behalf of Skywind Farm Information Group?
On the key matter of the evidence, topics and procedures, as I say, I have Mr. Campbell's notes in front of me. The only issue I'm not up to speed with, and maybe Fraser can help, is whether there was any negotiation on or any agreement on a revised set of dates for the inquiry.
Well, we'll come on to that, Mr. Kelly. That is one of the items on the agenda after the next one, which is about the additional information that the applicants are proposing to submit. Mrs. Ritter, I think your microphone is not muted. If you're able to mute your microphone, I think we're maybe getting a bit of feedback from, well, somebody from, or possibly Mrs. Wilson. Nope.
So I think it may have been me.
Oh, right, okay.
But as I indicated, my original computer's restarted, so I've come back on it. But I had both running very briefly. But if I lose contact again, I'll rejoin on my computer.
Right. Okay. Grand. Well, on the basis that, as I understand, Mr. Kelly is willing to proceed, I will continue. Is that I think if the webcast is not working, that's unfortunate. However, I mean, there will be a recording of the meeting. Oh, Stuart.
The webcast is working now. We had to delete that one, start fresh with a new one. That one's up live and that's running now, so that's okay.
Good. Okay. Right. Mr. Robinson, you're looking like you want to come in here.
Is there a new link for that webcast then, or is it the same link? Because I've got lots of people from Sky asking me why they can't see it, and the old link doesn't seem to be working. Stuart?
Yeah, no, it's a new link. I'm going to send everybody who I had the email addresses before the brand new link for that new webcast. But it's on the website, so if you just click on the website too, where people were, it's the one that's live now. But I'll send that link out too.
And the website is DPA TV, isn't it? That's the
yes,
Public Eye TV. Yeah.
Okay.
Grand. Okay. So item 4 on the agenda was the additional information and the scope of it, the proposed scope of it, the impact on the timetable. So when the applicant indicated they wanted to produce additional information, they did set out what they wanted to produce it on, which included proposed design amendments relating to track associated with the southern construction compound and with turbines 5 and 8, and the removal of Borough Pit 2. I think this is all set out in the agenda. It would be on the alternative of installing turbines up with a maximum tip height of 180 metres rather than the proposed 200 metres, and it would have an update of the assessment of cumulative landscape and visual effects. There's a statutory procedure for advertisement of additional information, which provides a statutory opportunity for public comment and for consultation with certain bodies, including SEPA, Nature Scot, and Historic Environment Scotland. The public have to have a minimum period of 30 days to respond to the applicant's additional information. When the additional information is submitted, my office will also give notice to all the people who've said that they want to take part in the inquiry that the additional information has been submitted. And so that will make everyone aware of their opportunity to comment and how long they have to do so. So I'd be grateful if the applicant can say when the additional information is going to be submitted, particularly if it can be submitted by the date I'd suggested on the agenda, which was 13th of February, and whether the proposed scope of the additional information is still as I set out. I think that's Mr. Campbell now. Great. Just wait a moment to see if he comes in. Mr. Campbell, are you there?
Good morning, sir, and I do apologise profusely.
I'm sure it's not your fault at all, Mr.
Well,
Campbell.
I'd rather think it is, but I don't know why, I'm afraid.
Okay.
So
Good.
apologies to all colleagues, because
Well,
it's very upsetting. But you're smiling, so that's a good sign, I suppose.
I'm very glad you're here, Mr. Campbell.
Thank you.
Good. Okay.
Thank you to Mr. Kelly as well for standing in. Much obliged.
I was just on agenda item 4, Mr. Campbell,
Yes.
which is the additional information and the scope and timetable. So I was just asking the applicant to set out when they intend to submit the additional information, and whether the proposed scope of the additional information is as I have set out in the agenda. And actually, there was one other point. I understand that the purpose of the design amendments, which is the first bullet point on of the changes that I've set out in the agenda, of the additional information I've set out in the agenda, the purpose was to address an objection from the Scottish Environment Protection Agency, SEPA. And I believe those amendments may already have been discussed with SEPA. So I'd also be grateful for an indication from the applicant of where they are in those discussions with SEPA. All right. So, Mrs. Wilson, I think.
Thank you, sir. If I can deal first of all with the SEPA objection and the first bullet point in paragraph 4 of your pre-examination meeting note. As you're aware, there's been correspondence between my agents and your office, with the original suggestion being that the response in respect to the SEPA objection and also certain respects of the Nature Scot objection, insofar as it relates to both peatland habitats and ornithology and protected species, was prepared some time ago and was close to finalisation for release. That has been a separate document to date, and I'm advised that it is being shared with Nature Scot and SEPA today. As the landscape visual impact assessment and the additional information associated with that is still in course of preparation. But it was thought that it would be helpful if Nature Scot and SEPA were given advance notice of the draft that's available. Separately, landscape visual impact assessment work, and specifically in relation to the update on the cumulative impact assessment, is proving time consuming. And so far as the applicant's witness is concerned and expert, it's thought unlikely that it could be produced by the 13th of February. And the request has been made to the legal team as to whether or not we might today seek the 14th of March as an alternative date, which no doubt would please Mr. Campbell, who's separately made representations about the difficulties he envisages in responding to the additional information on LVIA. So against that background, I would raise again with you, sir, whether or not it would be helpful if we were to publish the additional information in relation to the SEPA objection and the comments from Nature Scot by the 13th of February, and then formally request an additional 4 weeks for the additional information in relation to the landscape and visual impact assessment, which would take us to the 14th of March.
Well, I don't have a fundamental objection to that. My concern is merely the practical one, that it involves advertising 2 separate bits of additional information. But does anyone else have any concerns about that? Mr. Finlay or Mr. Finlay, Mr. Campbell.
So perhaps I can go first. In terms of the SEPA information, or the information that's primarily directed to SEPA, clearly.
Just hold on. I think John Campbell is just coming. He's frozen. I think he's maybe coming back into the. Mr. Campbell, are you there?
Yes, sir, I'm here. I
Oh,
can hear
good, good,
I can hear
good.
you fine.
Right. You're frozen on another part of my screen, but that's fine.
Oh.
Sorry, Mr. Finlay, if you continue.
You have the advantage of seeing Mr. Campbell twice. Yes. So in terms of SEPA, you'll be aware, obviously, that Highland Council had 3 grounds of objection. One is effectively reflecting SEPA's objection. If that's going to be withdrawn, then the sooner that is dealt with, the better.
Okay.
So yes, in terms of the updated cumulative landscape and visual effects, then I've no particular concerns about the date. I think, as we've indicated in our position statement, we do have a concern about you being asked to consider an alternative scheme with a maximum tip height of 180 metres. I don't know whether now is the time to raise that, or whether you want to raise that at another stage. But I understand Mr. Campbell has and indeed potentially Mr. Kelly's clients have similar concerns.
Well, I think probably now is the time to raise that. Yeah, if you want to speak on that now.
Yes. Well,
yeah. Go on.
We obviously don't know what difference it's going to make because we haven't seen the scheme, but in our submission, it could be a very significant difference. And if that information isn't going to be available till the 14th of March, and more importantly, if we only have 28 days to respond to it, that would be insufficient. Our primary objection, well, both our objections relate to the impact of the turbines on landscape and visual and cultural matters, and a new assessment would be required to be carried out by our landscape and cultural heritage witnesses, and it's effectively a new scheme because it is a significant difference if all the turbines are going to have a maximum tip height of 180 metres. So in our submission, it would be inappropriate for that to be dealt with as part of the forthcoming inquiry. There would need to be an application. Our submission is it should be a fresh application for what would be a quite different scheme. So you're on mute if.
Would it not be relevant evidence?
Well, I'm not quite sure what it would be relevant to if the scheme, the current scheme that is being proposed is for 200 turbines to 200 metres. The impact of turbines to 180 metres is in our submission a different scheme, and so the evidence. I can see the point that it's not entirely unrelated, but it's not of any significant relevance to assessing the impact of a 200-metre scheme.
What's your view on how long it would take for your landscape witnesses to assess the scheme?
Well, difficult to say until we've seen the scheme, but in our submission, it would put we're being asked to assess a new scheme. We don't have. It's not only just us that would need to assess it. Nature Scott might need to assess it. Their comments are based on a 200-metre scheme. Everyone else's input is based on a 200-metre scheme. It's a very significant change at a late stage, and in our submission would require a new application, as I've indicated. It's difficult to know how long it would take, to answer your direct question, to we have a landscape architect constructed for the appeal. He's instructed to work on a 200-meter scheme. The question is how long it would take him to review the no doubt significant further information and consider that a night, particularly if he's not going to receive it till the 14th of March.
Mm-hmm.
And we're looking at an inquiry date. My understanding is sometime in April,
Mm-hmm.
I believe.
Well, that's what I had suggested in the agenda. Certainly, yeah.
April or early May.
I think one of the key questions. Perhaps I should.
I'm also instructed we'd need to take the matter back to committee because it's not certain that Highland Council would object to a 180-meter scheme.
Right.
There's one thing to resite a borrow pit and make some certain design amendments in relation to a track which reflects a detailed matter. It's another thing to consider a wholly alternate size of turbine, which could or may have a significant different impact than a 200-meter turbine.
Is your submission that there would be substantial new reasons for objection that might arise from the different scheme?
I don't know is the answer to that. As I've just indicated, there may be no objection. There may be different reasons for objection. The reasons for objection may be altered by comparison to the current reasons for objection. It's one is tempted to say, oh, well, it's going to be lower, so your reasons for objection are going to be reduced. But one doesn't know whether we would. We don't have a position yet on a 180-meter scheme, and we need time to consider that. And that is not only just getting an assessment, but as I've indicated, taking it to committee too.
Okay. Thank you, Mr. Finlay. I'll ask Mr. Campbell if he's still here to respond also. Mr. Campbell, are you still here? He doesn't appear on my screen anymore. Oh dear. Stuart, Mr. Kelly is here.
Do you want me to say something on that matter, sir?
Could you do that? Yeah, we seem to have lost Mr. Campbell.
I think the position of the Skye Wind Farm Information Group would be to support what the Highland Council have said, that the 180-metre turbines should be a separate application. It's not just that the effects will be different. Presumably, the installed capacity of the lower turbines would be lower, and therefore any different or revised effects would have to be compared with a different set of benefits, leading to a different planning balance conclusion. And also from the perspective of just thinking of the poverty in the Highland Council just now, a separate application would give them an additional fee, whereas what you're proposing would mean the council would not get a fee for considering what is in effect a separate scheme. So the information group, Skye Group, would support the position set out by the council that this should be a new application if the applicants wish to pursue that.
Noted. It's not my proposal, Mr. Kelly.
It was your proposal to consider it at this inquiry, I should have said.
Mrs. Wilson. Well, no, I think I simply reported what the applicant said they wished to do. But Mrs. Wilson, do you want to respond to those?
Yes, thank you, sir. I reject the suggestion by Mr. Finlay that this is an alternative new scheme and would require to be the subject of a new application. The turbine positions would not change. They would be in exactly the same position. The only difference would be a lowering in the tip height of specific of the turbines. And to put it into proper perspective, with all due respect to those who have indicated that they consider a new application is required, what's being considered is an alternative form of mitigation, not an alternative scheme, as a possibility. But just to be clear, it's the primary position of the applicant that they would wish to proceed to consenting of the 200-metre scheme. And the only reason for addressing in the LBIA evidence the possibility of reducing turbine height to 180 metres is to consider what that alternative approach to mitigation might deliver by way of LVIA benefits. But it's not a scheme that would result in very significant differences. Noticeable differences, yes, but not very significant. And I'm advised that the landscape architect has informed my agents that so far as they're concerned, so far as she's concerned, she could produce.
Yes, working.
She could produce the visualizations by the date of 13th February. So therefore, at least that information would be available for parties to be advised as to the potential implications ahead of the narrative.
So she could produce the visualizations for the individual impact of 100. I'm sorry, is someone speaking? So she could produce. So she could produce the visualizations for the individual impacts of a scheme with 180-metre turbines.
Yes.
Right. I'm sorry, I think James Finlay dropped out there.
I did. I'm afraid hopefully you can hear me now. I'm back on my backup computer.
Did you must have missed
missed part of that.
Mrs. Wilson's reply. So, I'm sorry, could you go over that again, Mrs. Wilson, for Mr. Finlay's benefit?
Perhaps I can, to assist Ms. Wilson, I was there until she said there was no very significant difference, and I understood her point that it's an alternative form of mitigation. So it's just anything after those points that...
I think from recollection, the main point after that was that the visualizations of the alternative 180-metre turbine height could be produced by the 13th of February.
Okay.
Although the formal assessment that would accompany the visualizations wouldn't be available until the 14th of March.
But just to clarify, just a moment, Mr. Kelly, I have one question to Mrs. Wilson. Just to clarify, Mrs. Wilson, the proposal the applicant would make would be that if a 200-metre scheme was unacceptable, in my view, I would recommend a 180-metre scheme if I did regard that as acceptable as an alternative.
Yes, by way of imposition of a condition.
Yeah. Okay. Mr. Kelly. Oh, Mr. Kelly, you're muted.
Okay, so I should have said earlier that obviously we need to think through the implications of timings, whether it comes in as one set of additional information or two sets of additional information. Certainly, my client's landscape witness would need time to assess both documents and provide advice, and would need to be discussions within the team. I certainly think that if the additional information is produced, the additional cumulative information is produced in mid-March, then it would be almost impossible to hold an inquiry in late April, when, as I think you may know, I'm unavailable anyway. So
I got that. Yeah.
So thank you.
I think what we have to do is work out when the additional information is submitted, and then we have to work out the inquiry dates after that. We'll do that in the next agenda item. I think the question is what to do about the additional information and the council and Skye Wind Farm Information Group's objection to the proposed information on 180-meter turbines, or maximum 180-meter turbines. I think perhaps the approach to take, if I make this suggestion, I'll see what parties think of it. If the information, it's very difficult to tell the degree of impact that new information might have until you actually see it. So if the applicant is minded to produce the information, I can make a ruling at the time it is produced whether it is admissible. Is that a sensible way to proceed? Perhaps Mrs. Wilson first, and then Mr. Finlay and Mr. Kelly.
I wonder, sir, if I could just take instructions before responding on that point.
Of course, yeah. Ms. Wilson.
So, in principle, there's no issue taken by the applicant as regards your suggestion, and it's fully understood as to why it is you'd want to have something in front of you before making any ruling on the matter. The question is whether or not your preference would be that the visualizations in respect to the 180-meter height turbines is produced sooner rather than later. As I indicated previously, I'm advised by the landscape architect that could be done by the 13th of February, but that the reasoning associated with the EIA work would be produced at the proposed later date of 14th of March.
Right,
but she has already been working on those visualizations, and therefore it's possible that they could be produced so that individuals were able to take a view as to the significance or otherwise of the proposed revisal.
Okay. So I think it would be, well, Mr. Finlay and then Mr. Kelly.
The first point to make is without the visualizations by themselves, without the analysis by the applicant's landscape architect, is only a very partial picture, and it would be unfair to require anyone to take a position on the visualizations by themselves. Secondly, no friend says it's just lowering of tip height, but it's likely to be lowering of hub height too, potentially. She's indicated it's just an alternative form of mitigation. This is a matter that you can rule on in due course, but in our submission, there's a sliding scale and reducing the...
So I'm sorry, but Mr. Finley's breaking up and I'm not hearing what he's saying.
Yeah, but perhaps if you are you able to speak a bit more towards the computer,
Yeah,
Mr. Finlay, that might help.
Sorry, I'm struggling a bit with the various pieces of equipment on my desk. The hub heights might change in terms of whether this is mitigation or a new scheme. There's in our submission, changing the turbine heights of all the proposed turbines by 20 metres is clearly a new scheme. And my friend says no very significant difference, but it's impossible to make that assertion without having carried out the assessment. So in our submission, yes, the only downside of ruling when the
I'm sorry, could you say it again, Mr. Finlay?
The only downside of ruling post 14th of March is that post that date, in order to make our submissions to you, we'll have to carry out an assessment. We may indeed have to take the matter to committee. So there'd be some significant delay being introduced into the dates for the inquiry.
Mm-hmm.
In our submission, that if that's the course taken, then there will be significant delay for the inquiry.
Mm.
Yeah.
Is it not? But as Mrs. Wilson says, is it not just a matter of something that, theoretically I could do anyway in respect of the present application, that I could impose a condition reducing the tip height of the permissible tip height of the proposed turbines?
Well, you would have to form an assessment. Now, I appreciate, obviously, this is an Electricity Act application rather than a Planning Act application. Mm-hmm. But if this was a Planning Act application, yes, you would have to carry out an assessment of the extent to which the amendments made it a different application. In our submission, by analogy, the same approach it should be applied in fairness to Electricity Act applications. Yeah. It may well not be open to you to do that.
Mm-hmm. Okay. Right. Mr. We still don't have Mr. Campbell back.
Yes, you do have me back. I'm on a telephone, and I'm quite happy for Mr. Kelly to complete this point on our behalf.
Oh, good. Right.
Thank you, sir. We are in agreement with what the Highland Council have said, particularly in regard to the potential effects on timings. The only additional point I would make, sir, is that if you are minded to make a ruling on this matter at any time, that you invite representations from the parties before you proceed to make a ruling yourself, sir. Yeah. Other than that, just supporting the Highland Council's position.
Mr. Klein.
Just a small general comment. During the public consultation, the agency told us that everything below 200 meters is not turbine-wise, is not available on the market. I'm glad that this is obviously not the case. I was also in touch with some manufacturers, and it's clearly you can have them in all sizes. And I was just wondering, it seems to me that the difference between 180 and 200 and 180 meter will probably be not that significant. Is it possible to also get a visualization for a 150 meter height turbine?
I think that's not something that the applicant is offering to provide. It's.
I see.
And if although I'll put the point to Mrs. Wilson. I mean, if I can, if I'm entitled to impose a condition reducing the height of the turbines to 180 meters, could I not equally impose a condition reducing the height of the turbines to maximum height to 150 meters?
So the applicant's position is different with that level of reduction in height. The Highland Council had previously made clear, I think in its objection, that it would be objecting to anything more than 150 meters in height. Against that background, following the council publishing its position in that regard, there was discussion internally amongst the team and specifically consultation with the client as to whether or not the scheme would be viable if the turbines were reduced to 150 meters rather than 100 meters. And the advice that we were provided with is that 180 meters is as far as the applicant would propose to reduce, because any lower than that, there would be significant implications on the viability of the scheme. So it's not a proposal that the applicant would put forward.
Okay. Right. So to go through where we are with this, first, the information to SEPA the information addressing the changes in design of the tracks can be produced by the 13th of February. And I think everyone has agreed that should be produced by the 13th of February. No matter that there is a degree of awkwardness in advertising additional information twice, that there is an advantage in advertising additional information at that point. Okay. In terms of the cumulative assessment, we have the date in March, which, if you remind me, I think it said 14th of March.
Yes,
14th
correct.
of March, yeah. Okay. And I don't think there's any concern about the submission on the 14th of March of that information. Is anyone, nobody has anything to say about that, do you, Mr. Finlay, Mr. Campbell?
No, we don't. I don't think.
No.
We don't have a problem with that.
Good. Okay. But we have this issue of the submission of information about turbines of a lower height. The council say would may cause the council to have to take the matter back to committee, which could potentially extend and also to have to consider the matter further in the council's account. In the applicant's account, it's in the applicant's account, as if I understand it, this is just a mitigation that I could make. So I haven't seen the difference between these. The applicant's proposal is that the visualization should be produced by the 13th of February, or they could be produced by the 13th of February. The council's position is that that would simply be partial information, as I understand it, Mr. Finlay, and it wouldn't be fair to expect people to comment on that. Would a pragmatic solution be to produce the, there is considerable difficulty here in that the timeline for the inquiry will depend on the information that is submitted. And if the council's position, and I can understand the council's position, they will need considerably more time, might extend the period considerably before the inquiry can be held. And I think I did express that concern when the proposal was made last year to submit the additional information. Do you accept that point, Mrs. Wilson, that this could considerably extend the period for the inquiry can be held?
I think where there may be a difference is the use of the word considerably extend the period before the inquiry. There has been exchanges from other parties, in particular from Mr. Campbell, in terms of the dates by which he was favouring, which would be taking us in probably to mid-May, because the week suggested of 5th May, there are difficulties for the applicant with their witness. So we would have been proposing a 12th May commencement date. So that there's a substantial period of time between the production of the visualizations, albeit that it's partial information. There are landscape architects and other advisors who can make sense of the visualizations that could be produced, even without a narrative from the landscape architect. But it would provide background information and enable parties to begin considering the issues. Therefore, when the further LVIA information is submitted, that will provide conclusions in relation to significance of effects, as you would expect, which is where the most likely dispute will exist. And it's clear from the report from the Highland Council that there's fairly fundamental difference of opinion as to the significance of effects at the height of 200 metres. And my reading of that report is that the Highland Council wouldn't change its position unless there were turbines at 150 metres or less. So it's fairly clear to me that parties have already settled upon their position as to what height of turbine may or may not prove acceptable. And from that point of view, I still consider it more accurate to refer to this as an alternative mitigation strategy as opposed to a new proposal. The question therefore remains, what length of time do parties consider is reasonable? As you've already indicated, sir, 30 days is generally the statutory timetable for responses on additional information. And position on behalf of the applicant is that that remains adequate in the circumstances, given the information that's produced. That would allow for an inquiry to proceed mid-May if the standard 4-week period for lodging of inquiry reports, etc., was adhered to.
Yeah, the standard period is really quite tight, unfortunately. And that's why I proposed a longer period. Okay. Right. In principle, though, I think I will have to take this away and consider it when I'm producing the note of this meeting, and give a ruling on it or give a view on how we should proceed when I produce the note of the meeting. However, my view at the moment is that I should defer a decision on whether or not to accept the additional information on. Mr. Finlay, sorry, do you want to come in? You need to unmute yourself, Mr. Finlay.
Yes. I was only raising my hand just to. I wasn't meaning to interrupt your.
My flow, right?
Your flow or your provisional ruling. But I'll make the short point I was going to make anyway. It's not fair to say that Highland Council have settled position. Their position is going to be on the 80 meeting.
No, I understood that. I understood that. I think Mr. Wilson was stating an opinion on how she read the report rather than rather than saying what the council's position actually was. As I understood it. So what I would propose is that I make a ruling at the time that the additional information on the reduction of the turbine heights or the lower tip heights is submitted as to whether that is acceptable. It would be, I think my view is that it would be helpful to have the visualizations earlier, just so that people can prepare, notwithstanding that it's partial information.
Yeah.
But I would have to make the ruling at the time that the full information is submitted, which would be, as I understand it, on the 14th of March. Is that correct, Mrs. Wilson? Yeah.
Yes, yes, yes.
And I think we should, if everyone is content with that approach, we should proceed on the basis that that's, in terms of setting out the timetable for the inquiry, that's the way that it's going to work, and the Highland Council should simply will have to take into account that it will have to comment on the lower, on the potential, on the information on lower tip heights, in taking into account how long it needs before the inquiry. And we may just have to revisit that at the time the information is actually submitted. Is that satisfactory to everyone?
Yes, sir.
Yeah. Okay. Good. Okay. Right. So on that basis, well, the next item I have on the agenda is the reporter's provisional assessment of the main issues to be addressed and those requiring further procedure. So we'll take a look at those first, and then we can work out the date of the inquiry in the following item, participant parties, and then the date of the inquiry in item 7. Okay. So I set out my preliminary view in the on procedure in the appendix to the agenda, which I'm trying to put in front of me. That's it. And so just to remind everyone at the meeting, there are several options for further procedure in respect of the various topics that I've identified. I can simply ask for further written submissions on a topic. And if I do so, I would specify exactly what I want submissions on. I can ask parties to take part in a roundtable discussion is a second option, and that's a structured discussion led by me, in which there's no cross-examination. And I call that a hearing session. And the third option is that parties provide witnesses who may be cross-examined on the topic, and that's an inquiry session. Now, I'd proposed 3 topics for an inquiry session. One is the landscape and visual effects of the proposed wind farm. The second was, I don't think I quite wrote this down correctly, but it was the effect of the proposed wind farm on the setting of Dunvegan Castle and its garden and designed landscape. And the third was the effect of the proposed wind farm on peat. I think everyone is, well, just on landscape and visual assessment, I think it would be helpful if the applicant's evidence could cover the effects of its proposed second construction scenario. I think the council raised this in their comments, and including in which the 4 extension turbines would be built first, and the existing wind farm would be proposed to be in place for up to 5 years alongside the 4 new extension turbines. So that would be helpful. In respect of, I've clarified my position on the setting of Dunvegan Castle. As regards peat, I'd included it as being a topic for an inquiry session because the Scottish Environment Protection Agency had objected and made detailed comments on the issues, and because SNH, the Scottish Natural Heritage, Nature Scot, had made fairly extensive comments on the proposed development's effect on peatland habitats as well. Now, I understand that the addressing the concerns of the Scottish Environment Protection Agency is one of the reasons for the applicant's additional environmental information, and it may be that SEPA will withdraw its objection in the light of that additional information. So in that case, it seems to me it may be possible to step down the procedure in respect of peat, so that perhaps written submissions would be sufficient to address particularly the points raised by Scottish Natural Heritage to Nature Scot in respect of the proposed mitigation of the impact on peatland habitats, if that itself isn't addressed in the additional information that the applicant proposes to produce. Does anyone have views on that arrangement in respect of impact on peatland? Well, Mrs. Wilson, are you content with that?
Yes, sir. As I think has previously been indicated, the hope is that further information will satisfy SEPA and will address Nature Scot's issues as well. Mm-hmm. It's too soon to know whether or not the information that's been shared on a draft basis with these consultees will prove to be acceptable. But as soon as we have a clear indication, we can advise you on that.
It's unfortunate that neither Scottish Environment Protection Agency nor Nature Scot are here. I would expect them to take, if they continue to object, I would expect them to take part in an inquiry session. well, we'll just have to cross that bridge when we come to it, I think.
I think Nathan Scott's position, sir, is perhaps dictated by the fact they emphasised in their consultation response that it's not an objection. It's their comments on the application.
Right, yeah.
I
wonder if I might ask you a question. Sorry to interrupt. I wonder if I might ask you a question about the text in the left-hand column of this document. In the parenthesis, you put the words "and related carbon balance." And when I read that, I did wonder whether you were inviting submissions here about the carbon calculator material, which is to be found in the environmental statement.
I was thinking that, well, quite a number of the third-party objections had related to the impact on peat and the effect that would have on the contribution of the wind farm of the proposed wind farm to reducing the greenhouse gas emissions. So yes, I did have that in mind, Mr. Campbell.
It's very helpful. Thank you.
Covered in such a session.
Yes, I'm stopping short of suggesting that this should be an oral session, but it is material on which there are quite a large number of local views which have yet to be drawn together. And certainly, so far as Sky is concerned, it's not been possible to detect resident expertise, but the question has been asked whether that expertise should be sought for discussion of this matter. But I think I agree with you that it could be a matter which is covered in written submissions.
Good. Okay. I think, Mr. Finlay, are you content with the approach on peat that I'd outlined, on peat and peatland habitats?
Yes, I mean, yeah. I think it's my understanding is there have been initial discussions, and it's probably unlikely to head to, you will need an inquiry at this stage.
Okay.
From Highland Council's viewpoint, it's simply reflecting the objection from SEEP, so it has no independent stance to tell. So, in terms of mere administration, in terms of any note you produce following this meeting, it may be more sensible to move peat into a category of further written representations rather than the inquiry. It can always be reinstated to inquiry if that proves necessary. I think that is the more likely position that it will retain.
Okay, well, that's noted. Mr. Klein.
Yes, in regards to these points, also something that shouldn't be overlooked is that the infrastructure that we have on Skye, the streets, to kind of bring the proposed 200 wind turbines from A to B is just not there. And I think that should also be part of the discussion, because I think there were also some tests last year where it was clear that you cannot maneuver this kind of vehicles around here. So maybe that the infrastructure could also be a very important topic in that regard.
Right. So are you suggesting that? So I was going to come on to the topic of transportation just a little bit. In fact, I think, well, if I could just come on to that, because I had suggested, that for written submissions. But let me come on to that, Mr. Klein. I will come to that. Okay.
Sure.
Right. So. If everyone's content, well, I will do as Mr. Finlay suggests. I will peat and peatland habitats down, or pencil it in for written submissions with a view to reinstating an inquiry if the Scottish Environment Protection Agency's objection is sustained. So. As regards hearing sessions, I had put down two topics for hearing sessions. One was the interpretation and application of national and other policy, and the other was conditions that would be attached to consent. And I've had correspondence from Mr. Campbell, and obviously Mr. Klein has made representations just now that Mr. Campbell agrees that there should be a hearing on policy. He also suggests there be a hearing session on highways and transportation, as Mr. Klein suggests, and for socioeconomics and ornithology. And just coming on to the topic of highways and transportation, there do appear to be a number of issues raised, and particularly in Mr. Semler's objection, but also elsewhere, that do have a bit of some complexity. So these include things like how the seasonality of baseline traffic ought to be taken into account in the assessment, and what impact the seasonality of baseline traffic might have, the adequacy of the assessment of abnormal load transport, the adequacy of cumulative assessment, including the relative paucity of information on cumulative assessment of abnormal loads, and the adequacy of the mitigation proposed for transport, the impact for transport. So there's also some questions that might be answered quite straightforwardly, which written submissions would be adequate for, such as why 2 accesses for the proposed development are required. Perhaps since Mr. Campbell is suggesting a hearing on highways and transportation, perhaps I should come to you first to say why you think it's needed, and what way you consider the case would, what in broad terms, what case would you be putting, and how you present it.
Well, thank you. That's really helpful. I hope you can hear me all right. I apologize once again to all colleagues. I'm working on a telephone now, so if the camera's not very good, I apologize. As you know, sir, there's only one road from the north of Skye to the bridge, and that's a vital lifeline for all sorts of reasons, not least the emergency services and getting to hospital in Inverness if necessary. Everything is delivered by the A87. So closing this road and the Skye Bridge for abnormal load convoys will present serious difficulties, not to say possible danger if emergencies do occur. Now, I understand there's an alternative proposal to use the access to the west at Loch Carroy, and of course these comments have to be viewed in that light. But as matters stand, I understand that components are to be unloaded at Kyle and transported by road over a period of about 4 hours. And now, at present, so these roads are in very poor condition. Stretches of them are breaking up, and there are extensive resource difficulties so far as the local authority is concerned with keeping the road in good condition. So it is essentially about the size of the loads, the inconvenience it will cause to residents, the possible danger if emergency vehicles are not able to get access to the north of Skye. And lastly, the modifications which will be needed to the road surfaces, and also any bridges or bridge parapets, laybys and whatnot. And we feel, trying to sum this up and not talk for too long, we feel that on the whole, you would benefit from a confined range of opinion and information about the state of the Skye transport, as it were, matrix of fact. Tourism in Skye now is a 12-month reality. It's not uncommon to sit by the side of the road and count 30 or 40 camper vans going past, not just in season, as what we traditionally regard as season, but be done more effectively.
Okay, grand. Okay. Right. So subject to notice, which Mr. Campbell has undertaken to give, and we'll work out the timescale for that. We will we'll proceed with the hearing on transport. Now, the second issue that Mr. Campbell had raised for a hearing was ornithology. I think someone could do with muting. But could everyone mute themselves? That's it. Thank you. Okay. As regards ornithology, what I'd envisaged was primarily to give the applicant an opportunity to respond in writing to the comments of RSPB Scotland, who weren't actually objecting to the application, though they had suggestions about mitigation, including reducing the numbers of turbines. I think, well, perhaps I should ask Mr. Campbell why he considers a hearing necessary on this topic and on broad terms what he considers. I haven't seen representations of the kind of detail that or going beyond the topics raised by RSPB Scotland. So perhaps, Mr. Campbell, you could set out what you consider be required in terms of a hearing on ornithology.
Yes, and my position, thank you very much. My position is incomplete. When I saw this topic in the environmental statement, I asked a number of questions about it, but I have not been furnished with the expert evidence which I'd hoped to have seen by now. So my position about having a hearing on this topic is a little bit tentative. And I think rather than make any waves about it, I would content myself with you searching on a written submission for this topic. If the evidence comes forward, of course, I'll either try and reflect it in those written submissions, come back to you with a view that we should change the format. But I frankly don't think that's terribly likely. This is all a question, without going into the substance of it, this is all a question of the impact on the raptor population. And it's not a matter which is readily susceptible of research, because all the research can't be found in one place. However, it's certainly under review by SWIG, and we will do our best with the written submissions if that's what you settle on.
Okay, grand. I think that would, unless anyone else has anything to raise, I think that would be my view, that written submissions would be the primary way of dealing with this. Socioeconomics was the other topic. Perhaps again you could set out how you consider that would be approached. Obviously, there is some disagreement on socioeconomics in respect of what the third parties, the view taken by third parties, not least because of the difference in view taken on transportation but perhaps you could set out what your views are and why a hearing is required, Mr. Campbell.
Well, there is an objection dated in July 2023, I think, a long objection from Ms. MacLeod of Campbell Stewart McLennan, which will be in your paper.
I have seen that, yeah.
You've seen that? And you will have seen that there's a chapter and a very economical summary at the beginning of it. There are really 4 points. The tourism impact of this development and any others which come along in the meantime, but certainly this development will be hugely significant given the growth of tourism on Skye. And as I've said already, the fact that it's become a 12-month phenomenon. The developers have chosen to reduce the geographical area that they have considered to a very small area around Aketil itself and the road to Dunvegan, so that the result of their analysis is just the effect is considered to be negligible. With great respect, we think that is a flawed approach, and that they need to take a wider view. Second thing, which is of socio-economic relevance, is that we do not think that the developers so far have properly identified the significance of Skye's tourism economy in the whole socio-economic picture of the island. it's often said that Skye is a special place, and that's of course become a bit of a cliche. But economically, too, it has singular characteristics which require to be presented to you, and which will be impacted upon by the development as it progresses. The third point is about the data, the comparative data which is produced. Without going into it today, is, we think, based on mainland data, where projects such as wind farms often have alternative access routes and do not affect the tourism economy in the same way as Skye will be affected. We question the relevance of mainland data, or the use of mainland data rather, in this connection. And the final point is in relation to operational jobs. There's a figure of 48 somewhere, and that's quoted in the summary, I think, in the non-technical summary of the EIA. But within the EIA itself, a very much smaller number, approximately one and a half jobs is demonstrated. And so, I beg pardon, there's an internal inconsistency rather, about job creation, which we'd like to explore.
I don't want to anticipate the applicant's case, but I think I worked out the solution to that particular last point. I think it's perhaps the applicant. Perhaps the best thing to do is let the applicant speak to it. But it appeared to me that it was job years that were referred to. But perhaps we can come to the applicant. It was Mr. McLeod's.
Can I just finish answering your question? You asked me how we would present that, this socioeconomic analysis, and I'm yet to reach a concluded view, but my thinking is that a combination of the evidence of Miss McLeod and the tourism, I hesitate to call them an authority, the tourism information facilities on Skye, would be the best way to do that. I don't think this is a case for bringing in an economist, although that's certainly been considered. If I may just check, I'm getting a message about this just now, but I don't know if it's relevant or not. So we think we would use local witnesses. We think that probably there would be two. And of course, we're clearly in agreement that there should be a hearing session. And in advance of the hearing session, we would produce a statement which would enable you to formulate your question. That's the reason I think that socioeconomics should be in the hearing column and not in the written submissions column.
Okay. Ms. Wilson.
Thank you, sir. In relation to the fourth point regarding the number of jobs, I'm afraid I'm not in a position to answer that differential that you made at the moment. So far as the general principle of whether or not it should be by way of a hearing as opposed to written submissions, it's somewhat difficult to take a view on that without seeing a statement of case for all these, whether there's enough material that would justify a hearing session as opposed to written submissions. That's not very helpful in terms of resolving the point at this session. But insofar as it features as a ground of objection from the consultees, again, the applicant would rely upon the fact that it is not majored upon as a ground of objection. And that the inquiry sessions and indeed hearing sessions, so far as possible, be limited to what are most likely to be the determining issues.
Yeah. Mr. Robinson.
Yeah, I would say, harking back to the traffic and transport issue again, we've seen it's going to cause substantial disruption, the construction period from Kyle Port onwards. There's only one jetty at Kyle Port. So you're going to have more there with turbine components being offloaded and then somehow manoeuvred through a very small harbour town in Kyle, causing all the financial disruption to other users of the port and business in that area, and you're going to have road blockages up and down the island while the abnormal loads being shifted, causing business to supermarkets, depending on food delivery, to fuel delivery, to petrol stations, to tourists coming to the island. Skye will get a reputation as being a difficult place to get to, which is going to damage tourism. I accept there is no objection from the council at this stage on this matter, but the likely economic implications no correct.
But I'm sorry, do we think we might have lost Mr. Robinson?
Oh, I'm still here. No?
Oh, no, good, right, okay. But what does that say about does that necessarily mean that a hearing is required on it? These are matters that and in my view, I think could probably be addressed in written submission to the matter raised in Mr. MacLeod's objection. Is there a reason why it needs to be aired in a hearing, in a roundtable discussion? Is there complexity of the issues?
It's the same argument as before. We feel that this information is best transmitted to you in a contemporaneous way by people who live on the ground. My learned friend Miss Wilson's response is symptomatic of many large developers. And they talk to the authority, and they talk to SEPA, and they talk to NatureCot. But very often they don't talk to local people. And the most immediate evidence comes from local people, which is why we're going to all the trouble of coming into this inquiry. So we're not talking about, I think we're talking about 2 hours, maybe half a day at the best,
Okay. Mr. Klein.
Just to add to what Mr. Robbins said, I think, with all due respect, these applications are, planned by people in offices in cities. But I urge everyone, if you come here any day between March and September, it will be obvious for you what we're talking about here, because the island is packed with caravans on roads that are in an incredibly bad condition. You have potholes the size of, I don't know, cars. So I think this is a very academic thing to say. We can do this in some written statements. You have to just come here, look at it, and you see that this is it's just not feasible. But that's just to add to Mr. Robbins' comment. I think it should be discussed in a hearing, in my opinion.
Okay, I can see Mr. MacLeod. Mr. MacLeod, you want to come
in? Yeah, it's really difficult, I would say, to almost separate transportation from socioeconomic. And one major issue that seems to have been missed in this application is that the A87 doesn't just serve Skye as a lifeline route, it's also a lifeline route to the Western Isles, to Harris, to Uist. We're talking about, if we're talking about journeys that are going to be delayed by 4 hours in each direction, you're talking about people who are travelling an hour and 3/4 on a ferry journey, travelling through Skye, which normally takes them 45 minutes to an hour and a quarter, depending on the time of year. You're adding 4 hours to that. You're talking about then travelling towards the Central Belt. You're talking about lorry drivers who will have issues around the time it takes them to get from one place to the other, rest periods, all of this sort of thing. So the socioeconomic's been very much diluted to a very small area of Skye, when this has many, many impacts. We're talking about Skye being a lifeline route, not just for people on Skye, but also people on Raasay. Raasay's not mentioned at all when it comes to that, and the socioeconomic impact on them as well. So there are quite sizable issues around the socioeconomic aspects of this that just have not been touched on in the EIA at all.
Right. I'll give one final comment. Oh, sorry, Mr. Klein, do you want to come in? You need to unmute yourself, Mr. Klein.
Just one minor detail, not minor detail, but something I forgot to mention. We also have Talisker here, which basically every week requires to get 50 trucks in and out. So this has to be, we have to see this on top of everything. And they also use this road because they have to. So this is also, and of course, people work here, people come to visit Talisker, just to add this on top of the social.
We're getting into the substance of the matter rather than the procedure, but I think just in terms of the procedure, given the range of views that have been expressed in the relationship with transport, given that we're penciling in a hearing on transport, I wonder if it would make sense to have a hearing on socioeconomic effects to follow the transport hearing, subject to Mr. Campbell providing notice of what case he will be presenting.
Happy to do that, sir.
Mrs. Campbell, Mrs. Wilson.
Miss Wilson, yes.
Miss Wilson.
If I could just have a moment to,
Of course, yeah.
thank you.
Excuse me.
Thank you, sir. Consensus view of all of us is that a hearing session would be the preferable way to proceed.
Okay, that's grand. Good. Okay. There were a couple of other items that I'd mentioned, and I just want to mention them here in terms of written submissions. I'd mentioned contamination of watercourses as a matter for written submissions. I hadn't viewed particularly representations such as those from the Skye and Loch Ulsh Rivers Trust suggesting that contamination could arise during construction. I think it was simply to get a response from those objections that I was looking for written submissions. But there was a kind of related matter that I had thought of under contamination of watercourses, and it's a matter raised in quite a lot of the representations on the application, and it's not one that I've come across before, and that is the effect of leading edge erosion, or alleged effect of leading edge erosion of turbine blades. The effect is alleged to arise because particular materials used in blade manufacture, and I haven't come across any decision of a reporter or ministers that refer to this either, except very fleetingly, though I may have missed one. So I was wondering, I think it would be helpful, separately from the potential contamination of watercourses issue, to for the applicant to provide a written response on those representations too. If that's
Yes, sir.
content with that, good. Okay.
Yes.
Right. Now we've been going for just over an hour and 3/4. Perhaps it would be a good idea to take a comfort break just now. Is everyone happy to do that? I was hoping to take it a little bit later when we worked out the date for the inquiry, so I could have a look back and work out the dates for submission of documents. But perhaps now would be the time to take a break, and we can come back in say 10 minutes.
Yes.
Yep. So back at 5 to 12. Okay.
Hi, good afternoon, full stop. I will be keeping my existing email, which defaults invisibly to jdcampbell@advocates.org.uk. Full stop. The latter is my preferred email address now. Full stop.
Sorry, not. I think maybe not everyone heard me saying 5 to 12. Did I? Okay, I think everyone's back. Yeah. Okay. So we have to arrange the date of the inquiry that's next on the agenda. And I was just penciling out to myself, taking into account what we've heard in terms of the submission of the additional environmental information, what a realistic date for the inquiry would be. I think obviously the statutory date for responses to the environmental information, if it was submitted on the 14th of March, the statutory date for responses would be the 14th of April. The Council has made representations that it may require longer than the statutory period to respond to the proposed information on lower turbine heights. So the Council is unable to say at the moment, of course, how long that might be. So I was penciling in a date of 30th of April for responses on the additional information, which would take us, I think, for an inquiry to mid-June. Now, mid-June may cause its own problems in Skye, given it's getting into tourist season.
No. I'm sorry, but I meant it when I said it's a 12-month phenomenon.
12-month. Okay, right. Well, there we are. Okay. Well, we may just have to face those problems anyway. If we were looking at a date in mid-June, is that an acceptable date to parties here? Perhaps starting with the applicant. Sorry, Mr. Robinson, I'll come to you. I was going to ask Mr. Wilson to speak first, if that's okay.
We would have to do checking with witnesses as to their availability.
Yeah.
Some of them are involved in other wind farm inquiries, as you'll appreciate, and seems to be back-to-back inquiries being fixed at the moment. So certainly from my point of view, I'm available, but we'll have to check, and I think from your point of view as well. Those are my agents. It's but we'll need to check with the witnesses that have already been penciled in for the topics that we know about.
Right.
Obviously,
yeah.
the decision.
Sorry, go on.
I was going to say the decision today in relation to combining transportation and socio-economic, we hadn't given thought to who might be a witness, so that's a new issue that will have to be addressed.
Okay. Yes, that's noted. Mr. Finlay, in theory, a date in mid-June for Highland Council, is that acceptable, subject to verifying your witnesses can come?
Yes. Right now, I'm not available for the full week of the 16th of June, but I've got it on the guide slide.
Okay. So if we were to say the week of the 23rd of June,
Yes.
yeah. Okay. Mr. Campbell, is that acceptable to you and your clients? At least
Thank you,
in
yes.
subject to verification.
I'm on holiday from the 9th of June for 2 weeks, but the week of the 23rd of June is acceptable to me. I have to check with my witnesses, so I'll try. But Dr. Robinson is waiting to speak, so it may not suit him. I don't know.
But Dr. Robinson, I'm sorry, I've been calling Mr. Robinson.
It's not a personal problem. I live here. The practical problem is that accommodation on Skye gets absolutely fully booked in the summer season.
Yeah.
It may well be nearly now by that time of year. So if people are coming to Skye to take part in the public inquiry, it's got very difficult to find places to stay in that by the end of June. I mean, there have been times when police have been turning people back at the bridge because there's no accommodation available on Skye in the summer period. So a practicality.
I think that's just going to have to be part of the verification we do of the dates. I think we're if the 23rd, the week beginning the 23rd of June is penciled in, we'll just need to go and get accommodation as soon as we can. No doubt we'll be vying with each other to get it too. Subject to Dr. Robinson's comments, and I recognise the difficulties that there may be with that date, and we may simply have to revisit it in the light of those difficulties. The other option, of course, is to hold the inquiry by video conference, as we've held this meeting by video conference. But I think the reactions I'm getting suggest that that's perhaps not a sensible thing to do. Mr. Robinson, Dr. Robinson, I'm sorry.
Yeah, sorry. I mean, Skye struggles for internet bandwidth connection for many people, so you are going to have people having difficulties to join in an online conference. You don't have the internet infrastructure here to make it work.
No, I understand that. Yeah, that's why I thought an in-person meeting would be preferable. Yeah. Okay.
So, is there any possibility of giving consideration to whether or not, if the inquiry preferably took place in the summer, of looking at locations off Skye, as close as possible to Skye, but off Skye?
How do people feel about that? Perhaps, Mr. Finlay to start off with, and then I'll come to Mr. Campbell and the others. I see Mr. Semler's got his hand raised. I'll come to you, Mr. Semler.
Obviously, to me, is a matter of practical convenience. The reason why we're having an in-person inquiry is to allow local representation. So, whilst I recognise the difficulties of accommodation, which other council teams will face as well, it does seem to me that it's probably better.
Okay. I see Mr. Semler, Dr. Robinson, and Mr. MacLeod. So, Mr. Semler first.
Yeah, I think the idea of having it off Skye would be completely impractical. I mean, apart from anything else, the nearest place you'd like to have it to here is probably 2 or 3 hours drive from here, and that's even no traffic. So I think it's kind of Skye or not in person.
Yeah, it's quite far from Edinburgh and that area, and Struan and so on to even to Kyle, I guess. Dr. Robinson, did you want to add something to that?
Just to echo what Jeff said, it's difficult for community representatives to play a part in a process like this as it is. If we've then got to travel to the mainland, find accommodation to be able to take part with no funding, no access to resources like the applicants have, then you're skewing the whole public in favour of the applicants rather than making it equal.
Okay, noted. Mr. MacLeod.
Just a practical kind of suggestion is we've got a reasonably new school hostel that's owned by Highland Council here, which will be empty over the 6 weeks of the summer. So that might just be a possibility if accommodation becomes an issue and is problematic.
Right.
Yeah, anyway, sorry, thought I would just throw that in.
That's very interesting. Perhaps that's something the council could investigate, Mr. Finlay.
Yes, I'm sure we can investigate it.
Unless the council is hiring it out for holiday accommodation.
well, it's obviously we can well investigate as to whether there is could provide accommodation. What the standard, whether it could be appropriate or not, is another question.
Okay, grand. Well, thanks for the point, Mr. MacLeod. That's very helpful. We'll see what we can do in terms of accommodation. But so I'll pencil in then a date of 23rd June. The week commencing 23rd June. I would normally start an inquiry on a Tuesday. I would expect. Actually, I don't think. I would expect this kind of inquiry to be finished within 4 days. I was going to come on to the time that people expect to take. I would expect it to start on, if we say the week commencing 23rd June, I expect it to start on the 24th of June. Okay. In terms of a venue, Mr. Campbell suggested a number of venues, including the Skye Camanachd Social Club, Skye Gathering Hall, Edenbane Community Hall, and Dunvegan Community Hall. Does anyone have any strong views on a venue that I can ask our officers to investigate?
We've revisited this question, sir, without consulting my own friends. I'm sorry about that. The Skye Camanachd Social Club, which is the shinty club just outside Portree, has everything you could need for a public inquiry. Means it has good broadband, it has good parking. It's not that far from the shops. And it's plenty of space, including a retiring room for yourself. So frankly, the gathering hall, which is a bit grander, the public car park is a stiff walk away, and it's only 3 hours anyway, so people will be rushing out to feed meters.
Right.
And the village halls all have their own limitations, but they are there. I thought you should just have a perspective on everything that's available. I've not been informed about a hotel which might meet the bill. There's one I don't know, but I've not been informed about it.
Does anyone else have views on a venue? Town council have a suggestion? I'll ask my officers to investigate the. Mr. Semler?
Well, there is Gayboss House Hotel, I think, has got facilities for conferencing and things like that, so that might be a suitable venue for you, and that's quite close to the local area here.
Okay.
There's unfortunately a large billiard table in the most suitable room in the Gayboss House Hotel, which might provide some entertainment, but probably not much use to in public inquiry.
Okay. Right. That's very helpful. I'll ask my officers to investigate the Camanachd Club. Is it? I'm sorry, I'm awfully ignorant, but is that outside the shinty season? 23rd of June. Well, right.
It's in the shinty season, but it tends to be a building that gets used in evenings and weekends.
Right.
So it's quite a good venue from a daytime perspective, because they don't tend to rent it out other than for the odd event that pops up.
Good. Okay. In terms of item 8, I'm sorry. I think I've missed. I'm sorry, I've missed an item out, haven't I? We've discussed the
item 6, sir.
We've missed out item 6. Yes, we discussed the date of the inquiry, but we haven't asked parties who's to represent them and the scope of their evidence and so on. We have dealt, I think, to a degree with the scope of evidence in item 5. Perhaps I can just take parties in order. So starting with Mrs. Wilson, in terms of item 6, if you could just set out the answers to those questions that are set out in the agenda.
Yes, so I would be instructed to appear on behalf of the applicant on the instructions of Wright Johnson Mackenzie, particularly specifically Fraser Gillis and Amy Howard. Based upon the note that you produced and the content of Appendix 1, I can advise that it's proposed to lead Kelly Anderson as the landscape architect, Lynn Glancy as a cultural heritage witness. And so far as the peat issues, put it broadly, those related to the sea projection and Nature Scott's comments, that would depend upon where we get to. So I can't give you the name of a witness at the moment, as we haven't made serious inquiries about availability.
Okay.
And as I indicated earlier, the new hearing topics, that's something we'll have to follow up on. But so far as the proposed hearing sessions on policy and conditions, David Bell would be the witness for the applicant.
Very good. Okay. Right. I know it's very difficult to say, but in terms of time requirements for the applicant's case, do you have a view on how long it would take? Perhaps we could take that after we discussed everyone the witness everyone's putting forward. Yeah. Okay. Mr. Finlay, if you could answer those first two questions. Who's representing the council?
Well, I'll be representing the council. We'll have a witness for the landscape session, a witness for the parliamentary session, and a witness for the policy section. With the additional sessions that are occurring, depending upon whether we're potentially looking at the 180-metre scheme, if we don't accept our submissions on that, depending on what they may be, my concern would be that the inquiry could potentially run to 5 days. Without trying to assign particular times to particular subjects, it just, with the number of parties involved, it has a feel. So either it's potential for starting on the Monday, potentially morning.
Right. Bulk of that would be landscape evidence then, yeah.
Landscape, and then the design landscape, and then a number of hearing sessions, but they can all take that time.
Okay. And Mr. Campbell?
Yes, I will be appearing with the Sky Wind Farm Information Group. In the policy hearing, my witness will be Mr. Kelly. In the landscape and visual inquiry session, my witness will be Ms. Talbot Platt on Monroe Landscape. We haven't yet settled on the witnesses for the socioeconomic and transportation hearings. I suspect that in the latter, Miss McLeod will be one of the witnesses. Since it's a hearing, it's quite open to me to bring a couple of people with me, and I may just do that.
Okay.
I think that's all I can tell you at the moment, because clearly when you're drawing together a third-party group, there's a certain amount of there's some uncertainty about whether people want to take part or not, or are willing to take part, or indeed have the skills to take part. There are many of the people on this call who may decide that they want to throw their lot in with the Sky Wind Farm Action Group so that the whole affair could be streamlined in that way. We've done it before, and I think I can promise you we won't waste time. But I do share my learned friend Mr. Finlay's concern about 4 days being sufficient.
Right. Okay.
Whilst many people traveling on Sunday is a problematic or possibly problematic, it may be a better alternative than going into the following week.
Yeah.
Or following the Janet McNair model and sitting on a Saturday.
Well, that can be an option, perhaps. Yeah. Right.
There is a further thought. I don't know if you've considered this or not, but it's become, I wouldn't say commonplace, but it's become usual to invite local people who wish to make short contributions about particular aspects of a development of this kind to contribute, often to an evening session which is out of working hours. You haven't provided for that in this draft timetable, but if that came to be a matter which seemed to attract a lot of attention, of course I would draw it to your attention or draw it to the staff's attention as quickly as I could, with a view possibly devoting an hour or two in the middle of the week for that purpose.
Yeah, I have no fundamental objection to having such a session. Yeah, the reason I hadn't raised it was because nobody else had suggested it as a possibility.
I don't know that it's even a possibility. Never mind the reality in this case, but it just might be. And I mention it.
Right. Okay. So, yeah, Mr. Wilson, given the views, well, perhaps I should ask first: is anyone else intending to give evidence, at least at this stage, out with not represented by Mr. Campbell, but giving evidence on your own behalf? People on this call. No, everyone. Yeah, Mr. Semler, yeah.
Sorry, yeah, I mean, I'm tempted to say I'd want to be at the Highways and Transportation hearing as it's now, because it's an area which I have fairly extensive experience in, not very locally, but in the UK generally speaking. And you'll understand from the comments I submitted originally that I've done quite a lot of work on what the traffic loadings are likely to be and what the impact is likely to be.
Yes, yeah. Your objection would provide quite a lot of notice in terms of what your case would be, I guess. It might be helpful, I think, if you want to appear, that's absolutely welcome to appear at the transport hearing. If your case develops, I think it would have to be subject to similar arrangements to Mr. Campbell's position. It would need to be you would need to give some notice of what the case you intend to give. Although I understand you set out a number of criticisms of VI already in your objection, Mr. Semler.
The only reason I suggest it might be of value for me to be there is that if it's a round-table discussion, that's somewhat different. Having one statement and that's the end of my input or involvement. Say about the highways and transportation aspect of it. One of the obvious proposals that will likely come back from the applicant will be to say they want to do the movement at night. And if that's the case, I would recommend that you perhaps engage the service of the police at that meeting as well, because that's probably a significant issue to them, along with transport companies.
I see what you mean.
They are mandatory consultees in an EAIL movement.
Yes, they are. Yes.
One of them.
Yeah.
It's someone going to the proposition that police are never not doing.
Yeah. I wonder, does anyone have views on that? Because I mean, the police haven't objected to the application.
No, there's no the application doesn't specify daytime or nighttime. It's the whole position on transport is extremely, dare I say, woolly. It lacks any level of definition whatsoever.
I certainly haven't had police at an inquiry before.
It's simply because general policy of the police, certainly in the UK generally, I believe it's the same in Highland, is that AILs should not move during rush hour, of which it's hard to define what that would be on Sky, but do not move at night. And that is an issue. If opposition came back in order to mitigate the impact, I wanted to do the movements at night.
Right. Yeah. I'll bear that in mind, Mr. Semler. I'll have to think about whether any procedure and whether I can invite the police and whether, what I do if the police say they don't want to come.
They're normally happy to come as long as you pay.
Well, indeed. I think.
So I think the normal practice is that there is consultation with the police at the time that the relevant condition is being purified in terms of movements and transportation.
Yeah.
Yeah. It's I mean, I suppose they're responsible for permitting particular movements. The question is more about the impact the movements have as a whole, and I suppose that's what we would address in the hearing.
The point I'm making is that if it is viable to do movements at night, then a viable solution from the applicant may well be that they wish to make the movements at night. Now, I happen to know that some transport companies won't do that because they can't see the load as it's moving at night in the darkness. But again, on Sky, that's less of an issue because the daylight is pretty long here, so you can probably get a period of time which might be deemed to be nighttime movement by the police under normal circumstances. It might be acceptable under certain circumstances here. I don't know. I'm just trying to avoid getting into an endless loop of objections and rejections when there might be a solution.
And I wonder if I wonder if the police's attitude is simply something that has to be a subject of evidence and the hearing. Unless there's a specific evidence that the police won't allow something that the applicant is proposing, I'm not sure that it would be necessary for me to ask the police to attend. So Mr. Salt and then Mr. Klein.
Yes, you'll be representing Sky Boston District Community Council.
Right.
One of the things in relation to public services regarding police and fire, we're presently trying to talk to both of those services, mainly to get some written information from them that could be provided at the hearing, whether or not individuals could come as representations from those services. I don't know, as you've pointed out, but I think fire and ambulance, we need to find specific information about what strategies they have, because we have to remember that it's not just the replowment of Ben Aketil that will be taking place. There are 4 or 5 other projects across the island, especially up in the north end of our island, will be happening at the same time. So all of these things that we are talking about are going to be magnified greatly. It's not just the visual, multiplying the visual look of around the Edinburgh area. It's it'll be the cross island effect of all those movements, parts and things like that going on.
Well, again, I think that's probably a matter for as people you're trying to get information from the fire and ambulance. I think again it's a matter of evidence at the hearing, and particular evidence from the applicant for how they would address issues of movement to emergency services. So we'd have to address that at the hearing. I don't know if we can go further than that today.
But we'll be bringing information about that to the hearing if I can speak.
Okay, and you're representing yourself. You're not part of the. Oh, for Scabost Community Council, of course. Yes,
Yeah.
sorry, Scabost. I'm sorry. Can you tell me the pronunciation of it? Scabost, right? Okay, sorry. EA. I know. Yeah.
Yeah.
I just wasn't sure. Right. Okay. Ms. Klein.
Just a question in regards to the technical issues of the wind farm. A lot of the things that we've heard during the public consultation were not true, as it turned out when I was talking to manufacturers. I was wondering if in statements, for example, like that 150 meters are not viable, is if more information is gathered in the next months on that topic, is it then just possible to basically coordinate with Mr. Campbell and then we express it there, or do we need to create a specific? Is that just, does it fall under the points we're already discussing, or do we have to create an extra?
I suppose. I think if you wanted to give evidence on it in terms of the need for having turbines with a certain degree of impact, I mean, I suppose you could add it to the your landscape and visual evidence, but the fact is that the proposal is for turbines of 180 of 100 of 200 meters, potentially with a reduction to 180 meters. The applicant is simply not proposing to erect turbines of 150 meters. So I'm not sure. The fact that it could do, and the fact that you say it would be better, it's really about the acceptability of the applicant, of what the applicant is proposing, as opposed to the acceptability of another development that might be carried out. So I don't think I would. I don't think I would. You know, I don't know how useful that would be as a line to pursue.
But also in general, like how the efficiency from the technical point of view, the efficiency of these turbines, because we all, talk about turbines, but of course, most of the people don't really know how they work. And I think it could help, to assess the machinery if more information could be provided in the hearing. But of course, it's up to you. I don't know. I mean, it's just that a lot of the things what we heard in this public consultation turned out not to be true. And that's why I was wondering if we can point that fact out, that what we were presented with was just like, it started with the statement that they told us, that you cannot get on the market turbines lower than 200 meters. That's kind of, that was the main point, but then now other issues as well. So I was just wondering, is there a place for that, to kind of to give a bit of a context for it, what it means when the applicant makes certain statements.
I mean, I think I've set out the topics that I don't. I mean, I can only answer the particular points that you've made. I think that particular point, I don't think it's the kind of thing that I would feel necessary to pursue, for reasons that I've given. In terms of inaccuracies generally in the consultation that was carried out. Ultimately, you have the opportunity to set out your evidence on the particular application that's in front of the inquiry. It's unfortunate if there were flaws in the consultation, but ultimately, I don't think it's going to be determinative unless there's something very, very serious that you can point to. So I don't think it's something that's necessarily worth pursuing. Also, I'm not sure if I have a specific represent. The reason I've set out the topics that I've set out is that I have these are the topics raised in representations, and I know that there were quite a few representations about the consultation, the standard of the consultation, but they didn't go into those kind of specifics. Which, and even if they had, I think it's unlikely my recommendation would be changed unless, as I say, there was something, very, very serious and very, very misleading, which even then I'm not sure how much an impact it would have on minister's decision.
Okay, but if it would refer to a 180 meter high, like if whatever we say would refer to a 180 meter high wind turbine, would that be appropriate?
In what respect?
Just in a sense to when it's about efficiency of these wind turbines, how efficient is that size, in also in relation to the number of wind turbines, because also it's about how many wind turbines do we actually need, these things to give it, because I think it's also lacking a bit of a lot of things that are quite significant. We have to take for granted because the applicant says so, and we have, people don't have the knowledge, but that's my point, because in the end, it's also about how many the Highland Council has to decide. Not only is it happy with that height, but also the number of wind turbines. So that's a bit to provide some context there. That would be can be included in our in the Swick Wind Farm Group, for example, in our just to not lose that information. That's the.
Right. So I'm considering that point, but I think I see Mr. Campbell with his hand raised, and Mr. Salt. I'll come, if you don't mind, Mr. Salt, I'll come to Mr. Campbell first, because perhaps he has something to raise on this particular point.
I think actually what Mr. Klein is driving at, and it might be helpful just to offer to discuss this with him so that we could set the parameters of additional evidence, if there is any, and nail its relevance to the inquiry, because many of us have been here before, and we understand how these points come up. We don't want them to be straggling in a loose way. But I'll certainly make an effort to talk to Mr. Klein and see if I can pin down what he has in mind.
Right. Okay. That would be very helpful. Is that acceptable to Mr. Klein? And we can deal with this in any comments on the procedure set out in the note of the meeting. Yeah. Okay. Yeah. Great. That's very helpful. Thanks very much. Mr. Salt.
Yes. In relation to the applicant communicating with other companies that are bringing applications for wind farms on the island, it'd be very useful if they could provide information prior to the hearing and for it to be discussed at the hearing, at what level and what progress of communications they have with other companies regarding development of timetables, etc., for the movement and transportation around the island. As far as we know, there's very little information come down from them as regards how they communicate with other companies and how such timetables are being developed. So I think the local community would like to know, are they talking to each other? Are they developing timetables? In what progress and what level they've reached at the moment?
Well, Ms. Wilson, is that something that you would be able to, that the applicant would be able to cover in evidence in the hearing on transportation, that essentially in context of cumulative impacts, how they would be addressed of transportation?
So the issue of a hearing session on transportation arose today, and we didn't take any objection to it, but it's not something that we've discussed as a team as to what type of evidence we would lead.
Right.
Cumulative impacts have been highlighted, as I understand it. One of the reasons the Highland Council have engaged with the applicant about construction scenarios is on that matter, seeking to avoid cumulative impacts that might prove problematic. So it will certainly be something that we will have in mind to address in evidence, and we'll give notice in a statement of case as to how we're going to deal with that.
Mr. Salt, would it be your intention to take part in the hearing session on transport as well, along with Mr. Semler? Okay, so I think the same arrangement would apply, that there would need to be some notice of the case that you're making. I think normally, we'll come on to discuss this, but normally hearing statements are produced before a hearing. So everyone who's wanting to take part in the hearing produces a hearing statement. And perhaps the way to deal with it, just given the need for the applicant to have notice, would be for a hearing statement to be produced, perhaps for the objector to produce hearing statements, and then the applicant to produce a hearing statement subsequently, and then the matters to be dealt with at the hearing. Is that an arrangement that would seem sensible to people?
Yes, of course.
Mr. Campbell?
It's very simple. It's very sensible.
Okay. Mr. Wilson?
Yes, the applicant would be content, provided that there was the delayed submission of its hearing statement once proper notice has been given.
Okay, grand.
Yes.
So Mr. Salt and Mr. Semler may wish also to take part in the hearing section on transportation. Well, okay, well, or Scabost Community Council. Sent by Mr. Salt. Okay, right.
Yeah.
Okay. Right. Does that cover? I think that covers the matters that were raised. Mr. Campbell suggested an evening hearing. That has been for parties who simply want to make a short statement. That has been used in inquiries previously. So simply people who've indicated they wish to take part in the inquiry would be able to come along, simply read out a statement. The applicant would be there, but there wouldn't be any cross-examination, but I may wish to refer both to the applicant and for points of information and to the person reading the statement, maybe ask them a couple of questions about it, about the match that they're referring to. And that would take place at a time when more people can come. So possibly in the evening, though, with Skye's tourist economy, perhaps that's not necessarily the most convenient time. Well, first in principle, is that acceptable to the applicant first, and I'll ask other parties, is that acceptable to run an evening session in that way if there's demand for it?
So, I've had experience of the evening sessions, and particularly in more recent inquiries. My specific question, so far as this inquiry is concerned, is whether or not you would be expecting that any statements were related to the topics that you'd identified for discussion in evidence at inquiry, or whether it be more wide-ranging.
I think it would, if effectively, well, I wouldn't be expecting people to raise topics beyond what I had asked for written submissions for, partly because I don't think there have been topics raised beyond those, beyond the matters that I've listed. I think one way of dealing with any issue of notice would be to ask people to provide their written statements perhaps a week in advance, if they're going to read them out.
So,
Mr. Campbell, yeah.
I don't want you to elevate this into something that it's not yet. All I was wanting to point out was that if there is a demand, would you consider it? And you've said you will. Yeah. And of course, I can't speak for the whole of Skye, but if a demand comes to our attention, then we will let Mr. Kennedy know, and we can plan accordingly. Ms. Wilson's point is a perfectly good one and a perfectly fair one. And obviously, if people can be embraced within the SWIG umbrella, then so much the better.
Yeah, good. Okay, so what we'll do in respect of that is perhaps leave that until Mr. Campbell's verified with SWIG whether he considers the demand for it, and people can comment on the note of the meeting as to whether they consider there'll be demand for an evening session outside the evidence that people have already proposed to give. Ms. Salt, your hand is still up. Are you wanting to come in? Oh, you need to. That's it. Good. Okay. Right. Good. You don't have a point. Right. Grand. Okay. We'll move on from that. we've discussed the date. The timetable for documents and written submissions and recognition. So I was scribbling down a series of dates, I think. Now, if we have, but I think that's maybe not relevant given how far we're into June. So just counting back from June, if we were to say would give us a bit more time to consider information coming from the EIA. Perhaps if we pencil in a date for I'll just look at my calendar of dates for response on the EIA for the additional information for response to the additional information of 30th April, would that be acceptable? Subject to the fact that the council may have to consider, and council and SWIG may have to consider what time it's going to take them to respond to the question of 180 meter turbines. But it would in theory.
Can you say the date again?
I'm sorry. Yeah. Would a date for responses to the additional information? Would a date of 30th of April be acceptable in the council's? Well, first in the council's view.
Anticipating that it would come forward
with
13th of February and 14th of March.
Yes, that's right.
It would as far as SWIG's concerned, yes.
Right.
So as far as the council's concerned, my understanding from your earlier indication was that once we've received the information, you will make a ruling as to whether that information should be accepted.
Yeah. Yeah.
So there are, if you like, two hurdles. I can't tell you at the moment whether I can't say at the moment whether the 30th of April would provide sufficient time to provide a full response. But it provides, certainly would provide, I think, sufficient time for us to be able to make submissions to you.
Okay.
If the matter does go forward to the inquiry, we will obviously have more time to present our evidence. So we can provide some form of response on it probably by the 30th of April, together with any submissions as to whether it's appropriate it should go forward to the inquiry.
Right. Okay. In terms of
Sorry, you're cutting in and out again, and I didn't get that.
Me, yes. Okay. No, I was speaking in incoherent sentences, Mr. Campbell. I was just trying to think through my position.
Sure you weren't.
I think was perhaps the answer. If we say 30th of April for pencil in a date of 30th of April for responses to the additional environmental information, would it, Mr. Finley's response suggests to me that the council considers it wouldn't be in a position to produce documents at the same time for the inquiry or its inquiry statement for its witness. Is that correct?
It's difficult to say.
Yeah.
We certainly couldn't produce a report at the same. I wouldn't. And if we're looking at a date in June for the inquiry, then the report could be. We need to have your ruling, and then we produce our evidence in May. I would hope by the 30th of April, thereabouts, we would be in a position to make at least submissions to you on it and provide it. But again, there are the problems of getting, if we're to provide, if I don't know how that's going to fit in with any committee timetable if it's decided that matter needs to go to committee.
I'm sorry, I didn't catch that last part, Mr. Finn.
I don't know how that will fit in with any committee timetable if the matter needs to go to committee.
Mm-hmm. In a way, that's the council's position on the additional information. I suppose it's important to the council's case internally, but the council is objecting to the main proposal, which is the 200-metre turbine. So in a way, it doesn't affect the inquiry's procedure.
It's only if the 180-metre turbines are going to be part of the inquiry, then we'll need time to deal with them.
Mm-hmm.
So there has been a full assessment by the council's landscape officer already, and also the planning officer who's been involved in this. It's not as though it's a new scheme, contrary to Alana Penn's submission. It is a proposed mitigation associated with an existing scheme that's been known about for some considerable time. It's not something that is going to require individuals who are trained in that field to take weeks to get their head around. And there is 7 weeks between the 30th of April and the proposed start date of the 23rd of June.
That was what I was thinking too. I think 30th of April does give quite a lot of time. I would think another 2 weeks after that. If that, obviously we're going down 2 timelines. There's a question of what I make of the additional information on reduction in height of turbines. Once we receive that information on the 14th of March, I would make a ruling as soon as I possibly can on whether it's acceptable, subject to submissions of parties, which I would expect shortly after the submission of the information. So I would make a ruling as soon as I can on how we would proceed. But I think I said earlier that we proceed on the assumption that I would that would be part of the inquiry, and I think that we're setting a date of if we pencil in a date of the 30th of April for responses to the additional information, that does give the council a certain amount of time to respond. And if the council needs more time, then I think we would simply have to revisit the dates we've penciled in for the inquiry and dates we've penciled in for the submission of documents at the time. But I think for the purposes of this meeting, so we can set dates to arrive at the inquiry of 30th of June, I think we should proceed on the basis that the 30th of May is the date in which submissions in response to the additional information are made, and that on the basis that the additional information will include 180-metre turbines. Sorry, Mr. Campbell. Oh, you need to unmute yourself, Mr. Campbell.
It's the 30th of May, but I think you may have meant
30th of April. I'm terribly sorry. Yeah, 30th. Yeah. Thanks for correcting me. Yeah.
Not at all.
Okay. If we proceed on that basis, then working forward in terms of when we want the documents to be submitted, pencil in a date subject to what I've said. I would suggest perhaps 2 weeks after that, which would give us 5 weeks before the inquiry, which makes it not quite such a tight deadline. Is that acceptable to everyone? 4 weeks is 4 weeks is the statutory period before the inquiry, I think, or the period set out in the code of practice. But I think that is very, very tight for a development of the scale of the scale proposed. So it would be useful to have a bit more time to both for me to examine the documents and for our staff to get the documents online, for the applicant for the document list to be compiled and so on. So I think 5 weeks is the closest we should go to the inquiry for submission of documents.
So that would be acceptable to the applicant.
Okay. Does anyone else have a comment on that? Yep. Okay, good. Right. Now, I think I mentioned, sorry. I've mentioned.
Is that a date for hearing and inquiry statements and documents?
That's what I would propose, yes. So
yes.
Hearing statements would be in the same day as the inquiry documents. The inquiry documents are all the documents you want to support your case at the inquiry. Hearing statements, so that well, now we'll need to think about hearing statements. I said that the hearing statements for the transport session, and perhaps also by analogy for the socio-economic session, from the objectors should be submitted before the statements from the applicant. So would it be acceptable if I asked for the statements on the socio-economic session from the objectors to be made 7 weeks before the inquiry? So effectively at the 30th of April. Is that what would you be content with that approach?
Yes.
Sorry, Ms. Wilson.
Mr. Campbell, yeah, start off with, and then Ms. Wilson. Ms. Campbell?
Did you mean? I was just seeking clarification. Did you mean socio-economic and transport hearing session? Yes. Thank you.
Yes, I believe that date would be acceptable. Thank you very much.
Good. Okay. So we'll just need to work out exactly what date that is. So it would be 30th of April for EIA responses, for additional information responses. 30th of April also for the objector statements on transport and on socioeconomics.
Yeah.
The 2 weeks, hold on. It would be.
Oh, sorry. Excuse me.
It's okay. The 14th of May for inquiry documents. Well, inquiry and hearing documents. For other hearing statements, including the applicant's response on transport and socioeconomics. For statements of agreement between the council and the applicant. I think I've set out in the agenda that I would encourage the council and the applicant to reach agreement on as much as possible, and other parties as well, Mr. Campbell, if that's possible. But with a statement of agreement, it is very helpful if the third parties have an opportunity to see it before the inquiry. So I would like it to be submitted with the documents of it if it can be produced. So the inquiry documents usually include what I've called witness reports. So if you want to produce evidence that's longer than 2,000 words, then you would normally produce that. A witness would normally produce that as a document, which they would submit with the documents. And 2 weeks before the inquiry, normally we receive precognitions, in other words, witness statements. So in this case, that would be a deadline of the 9th of June.
Precognitions would only be confined to landscape and visual matters.
Yes, and to cultural heritage as well.
Cultural heritage, yeah.
Yeah. That's right.
Thank you.
Good. Okay. Have I missed anything out? Draft conditions. Yes, it'd be helpful if the draft conditions agreed as far as possible between the council and the applicant could also be submitted by the see what meeting we I say the 14th of May. Yeah. Okay. Good. Okay. Does anyone have any comments on any of those dates? Is everyone content with that?
Yeah.
Okay. We're getting there. Right. Last few points. So next point on the agenda is site inspections. I would propose to visit the site unaccompanied in March or April or possibly May now. If anyone wants to point me to particular places I should go, obviously that will be before you submit your evidence. So if anyone wants to, if the parties want to give me a note of where I should go, I'm happy to take a look at that in their view. It's not essential. I will look at the evidence. I will certainly visit all the viewpoints. I will travel the roads of Skye, and in general, I would just try and work out for myself what I need to see. But if you want me to point me to particular things, I'm happy to take that on board. One thing I would ask, particularly the applicant, but perhaps the council as well, or Mr. Campbell, given your experience, is there anywhere I can go and see a turbine with aviation lighting similar to that proposed by the applicant? If you could advise me on that. I'm not asking you to tell me right now.
I think it probably is. We'll certainly keep them away and let you know.
Great. Okay, that'd be perfect. Okay.
So the applicant will advise as well.
Great. Thank you. I think the IA said it was a relatively new arrangement, so I'm not sure how easy it'll be, but we'll see. Maybe I think as regards an accompanied site inspection, I think we can maybe work that out closer to the inquiry. But I've just raised that point. If parties do want to accompany me on a site inspection, the normal practice is for the applicant to make arrangements liaising with other parties, and we'll work it out at the time. Yeah, Mr. Campbell, did you want to say something, or was there?
No, I just
No. Are you agreeing?
I thought you'd finished, and I was going to say something, but I'm not going to say anything until you finish.
Oh, well, I have finished. I have finished now. You can say something now.
Well, did I ask you to ask Mr. Kennedy to please get off his mark and book the Shinty Club if
Yes.
If you're persuaded that it's a suitable venue, because accommodation is so very difficult on Skye.
Yes. We have form that venues have to fill in, I'm afraid. So checking things like broadband access and accessibility for people. So we will do it as soon as we can. Yeah. Mr. Salt.
Yeah, is don't know whether it's appropriate or it's a requirement or whether it's something you would do to make yourself aware of the other planning proposals that are very well in line with the Ben Aketil repowerment.
Mm-hmm.
Is that something that you would do?
Well, I'm hoping that the applicant's evidence is going to do that for me. The applicant is proposing to submit evidence in its additional information on cumulative effects, which I understand would bring the evidence up to date with the current proposals for wind farm developments on Skye.
Right.
Is that correct, Ms. Wilson?
Yes.
Yeah. Good.
And that's a matter that I'll raise under item 11 in terms of the cumulative impact and cut-off date.
Right. Okay. Great. Okay. I've set out the contact for the at the DPA in the next item, and I've said that I'll produce a note of the meeting. So we are on to item 11. So, Ms. Wilson, you wanted to raise something about cumulative?
Yes, so in terms of the cumulative impact, landscape architect who's presently engaged in that work has flagged up that there is quite a lot of work involved, particularly in relation to visualizations, etc. And the applicant would propose that today be used as the cut-off date in terms of schemes that should be included in that cumulative impact assessment.
Well, it's not really a question for me. The problem for me is that at the time of the minister's decision, matters that are relevant to the decision have to be taken into account, as you know. I don't have subject to anyone else's comments, I don't have a particular problem with the cutoff date being today for that evidence, but it may be that if something else comes along, I simply have to take into account. I think, does anyone have a concern about that position? Mr. Campbell?
Does that mean the applicant is aware of other applications that the local communities aren't?
Well, applications are public. They're made publicly on public websites. So they're made either to the council if they're under 50 megawatts, or to the Scottish ministers. And notification is given of applications. So people are informed of the fact that applications are happening. If another application should come along, I think it would probably be in the interests of the applicant to draw that to the attention of the Scottish Minister if it did happen, if there was something significant that happened. Because if it was left out, that would potentially be problematic for any decision that was made on the basis of something that had happened that was relevant, but wasn't taken into account by ministers. So it may be that at that point, either if I'm still dealing with the case, or ministers will have to ask for more information, and that's just simply the way these things sometimes work. So one of the reasons to try and get these cases out of the way as quickly as possible is so that doesn't happen. So there isn't something that intervenes that means that I have to go back and ask for further information. I'm sorry, that's the best answer I can give you, Mr. Salt. I'm sorry,
it may inform other people's comments they want to make, but I should just flag out that Glenullinish that would be included in the scheme. At the moment, we only have the details as submitted, although the applicants have made it clear that they propose revisals to the scheme, but it's intended to progress with the application as submitted, and a view will ultimately have to be taken as to whether any additional information has to be provided to take account of any changes.
Right, okay, right. Well, it would be very helpful if the applicant could keep track of that and let me know if anything does happen. Yeah. Okay.
If I may, sir, implicit in my learned from Ms. Wilson's suggestion that she's talking about schemes which are within the planning process. I'd just like her to confirm that within the planning process includes schemes that aren't scoping. Or if she didn't mean that, then could she let us know that, because it's important. There's a peculiar aggregation of wind turbine development in this part of Skye, and so it is actually quite important to know what's included and what's not.
So I think one scheme in particular has been identified as being at scoping. There's not an arbitrary line that's been driven. Judgment is required on part of the landscape architect in the first place, or sometimes where consultees give direction as to what they would like to be included. But if it would assist parties, what we can do is produce a list at this stage of the schemes that is intended to include in the cumulative impact assessment, rather than wait for the additional environmental information to come out.
Well, are you in a position to say at the moment whether scoping schemes would be included or not?
It would depend. if it's considered to be directly relevant to the assessment because of proximity into visibility, etc., yes, but not as a blanket suggestion. It does depend upon the interaction between what's at scoping and what's being proposed.
Right. Okay. So if something's far away, then you wouldn't, even if it's perhaps theoretically visible, you wouldn't necessarily include it.
Yes.
Right. Okay. So Mr. Klein and then Dr. Robinson.
Just also to add, also the Talisker distillery is in the process of planning a new distillery. They want to double the size and double production, which will also be, this will happen in the next 2, 3, 4, 5 years. So it also will be a considerable amount of lorry traffic and all of that also should be taken into account when we assess the socioeconomic impact of it, I think.
And that's a matter. Yes, that's a matter for the transport
Sure.
case. And
it will be significant next years, definitely. I mean, because they have to do it because the old distillery is basically falling apart, and of course they wanna increase the production. So it's will definitely be a factor in the next years.
Well, I imagine the applicant will note that for that case on transport, and they can be discussed at that time. Good. Dr. Robinson.
Yeah, we're anticipating an application for another workers' camp to come online in Breakish before long from SSEN to build the overhead power line. There's a workers' camp proposed in Broadford, and there's a wind farm at Breakish. And although these may not be visible from the site, then they all share the same access road again, the A87. They're all part of the cumulative impact. If all these things are being built at the same time, they need to be considered by the applicants as part of the cumulative impact.
When you say the cumulative impact, you're meaning the cumulative impact in respect of transport. Is that what you're saying?
Yeah, among other things, and socioeconomic impact as well. Yeah.
Right.
I don't think the applicants can just brush those under because they're not visible from Ben Aketil or whatever. We're one small island, one access road, and all of this stuff is proposed to be happening at the same time.
I think the issue is in terms of the perhaps the applicant can respond to this point. I mean, in terms of the cumulative assessment that's being done for the or the update that's being done for the additional environmental information, that's for landscape and visual effects.
That's correct, sir.
You wouldn't necessarily be looking at cumulative developments for transport, but that can be dealt with in the transport section. There's no reason why it shouldn't be dealt with in the transport section. It's simply and socio-economic section as a knock-on effect, but that would simply be a matter for evidence at the time.
Yes, sir.
At the time of the transport section.
It wouldn't be caught by the environmental impact assessment regulations in terms of requiring intimation and publication. It would be dealt with in the transport session with the appropriate qualified transport witness if the view of the transport witness was that particular developments could lead to cumulative impacts on the road network associated with
It would be significant at that point. You would need to look at turning that into additional environmental information and advertising it.
If it would be significant, but at the moment it's not considered that is likely. But that the questions will be asked, the relevant questions will be asked of the appropriate transportation witness once selected.
Right. Okay. Dr. Robinson, does that cover your point? I think
it's a considerable cumulative impact from mass scale industrial across the island. We're an island, we are an island, a Scottish island, subject to the Islands Act. And the overall cumulative impact of all these projects needs to be considered about whether it's even feasible to build wind farms of this size and scale. So scale, all of that should be being swept up together. But definitely food impact and things. If you've got, you know, thousands more HGV journeys going on as you build it the line and 4 or 5 other wind farms at the same time, then there's a cumulative impact that needs to be considered.
Yeah. Well, Dr. Robinson, just in terms of, no, I don't want to get into the substantive evidence, but from what you're saying, I understand your position to be that there would be a significant cumulative impact. You would be entitled to make that argument as a legal argument, I think, that if there is significant cumulative impact, it should have been dealt with in environmental impact assessment, which should have been advertised, and that permission consent can't be granted without that being dealt with through an environmental impact assessment. So I think that's a matter for, it's both a matter for your evidence at the transport and socio-economic session in terms of what the cumulative impact would be, and also a matter for legal submissions following the inquiry. If the applicant doesn't necessarily concede the point, the applicant has said that they're going to consider it. Yep.
Okay. Yep. Okay.
Okay. Is there anything else that we need to discuss before closing the meeting?
As far as the applicant's concerned, there are no other issues to raise, sir.
Good. Mr. Finlay?
Nothing from the Highland Council.
Good. Mr. I'll go to Mr. Klein before I come to you, Mr. Campbell, simply because Mr. Klein's raised his hand. He's obviously has something he wants to say. So,
this just a general thing, and I just say it here because there was no point in discussing it beforehand.
Right.
But also this ongoing discussion about how is the community actually benefiting from it, because we have the high energy costs, as you know. So yes, there's discussions about giving from the the applicant giving a certain amount of money, but there's nothing in writing. There's no way, and even now we know that a lot of other wind farms don't pay what they actually tell the communities to pay, and also these wind farms most likely in the future will get sold to other parties, so there's no obligation to pay. So all this topic, there's nothing coming back so far essentially from the applicant, and I think that's something to keep in mind. I know it doesn't relate to a specific point, but it's just something that I think is very important.
The reason, Mr. Klein, I haven't covered that in the agenda is simply because it's payments by a developer or wind farm operator to members of the public are not relevant planning considerations. I know that they're often mentioned in environmental impact assessment as a benefit flowing from the development, but it's not actually something that I can take into account, I believe, and certainly ministers have taken that position before, that they can't take into account in deciding whether or not to allow the development. The reason being that effectively, ministers, you shouldn't be able to buy planning permission, so payments from a developer to communities might be regarded in that way. So whether or not they're made is unfortunately not relevant to the decision.
That's true. It's definitely not relevant for the decision. It's just, I think it's a bigger question of losing public support for this whole idea, of doing this corporate approach to wind farming. So it's just something to keep in mind, and I hope that in the future maybe there can be a policy established that kind of, because it's a big issue. It's a really big issue.
I mean, I've seen submissions elsewhere also about the proposal that there should be that development should be community development and so on. Again, that's not really relevant to the decision or to the recommendation that I have to make to ministers and to the decision ministers have to make, because in that case it's this proposal that they have to consider, not a potential community proposal. Okay. Mr. Campbell, I'm sorry, you were going to speak.
I was just going to say to you and my other friends in particular, but everybody really, that the beginning of this meeting was a complete shambles owing to my faulty broadband. I've been investigating what went wrong, and I've not been able to explain it. So I do apologise to you all for causing a substantial delay.
Not a problem, Mr. Campbell. Good. Okay, so unless anyone else has something to say, nope. I'll close the meeting there. Thank you very much, everyone. It's extremely useful.
Thank you.
It is a good chunk out of your time. So thank you. Thank you for attending.
Thank you.
Thank you.